All right, let's get into it. Hello, everyone. Thank you for joining the Colorado HOA Information and Resource Center's March 2024 HOA Forum. Today's forum is entitled Let's Talk HOA Liens with special guest Lindsay S. Smith of the Colorado law firm, hopefully I pronounced this correctly, Winzenburg, Leff, Purvis Payne. My name is Nick Altman. I'm the HOA Information Officer. Joining me today from the Division of Real Estate is Amanda Lopez, Program Assistant for the HOA Center. Hello, Amanda.
Hi, good afternoon, everybody. Thank you so much, Lindsay, for being with us today. And thank you, everybody, for joining us. Happy Friday.
Awesome. And Amanda, thanks for joining us. Amanda's going to explain what the HOA Center does and does not do. Amanda?
Yes. Thank you again, everybody. So we will go into, of course, what the HOA Information and Resource Center does. The HOA office provides information to homeowners regarding the basic rights and responsibilities under the Colorado Common Interest Ownership Act, which is also known as CCIOA. We also gather and analyze and report information through complaints and HOA registrations. The HOA office also creates resource materials, provides a website with information for the public, register HOAs pursuant to 38-33.3-401 in the Colorado Rights Statutes. And we also provide an annual report to the legislator. Going into what the HOA Information and Resource Center does not do, it is not a regulatory program. It does not mediate or arbitrate. We cannot provide legal advice. We do not act as an advocate, cannot assess fines or penalties, and last, we do not enforce an HOA's failure to register.
All right, thank you, Amanda.
Thank you.
Just a quick disclaimer, the information provided during this presentation is for educational purposes only and is not meant to provide, nor should it be construed as legal advice. Any legal questions you may have, please be sure to direct toward a qualified licensed attorney in Colorado. And just a couple more housekeeping items before I turn it over to Lindsay. For today's presentation, you will be able to submit questions in the Q&A feature on the bottom of your screen. We'll try and get your question answered as time permits. If your question goes unanswered, please feel free to email Dora_DRE_HOA inquiries at state.co.us after the presentation. And additionally, the HOA Center solicited questions in advance of today's forum. And I wanted to thank everyone who did submit a question. As always, we did have some great questions posed, and our guest speaker today will try and answer your questions toward the end as she is able. And just as another friendly reminder, this presentation will be recorded and uploaded to the Division of Real Estate's YouTube channel. A link to our channel is included on the bottom of this slide. And last but not least, as many of you know, the HOA Center exists to assist the public in understanding their rights and responsibilities under CCIOA. Because we do serve the public, we hear from multiple stakeholders in the HOA industry, including homeowners, community managers, attorneys, realtors, and board members. Types of inquiries we receive range from how to properly conduct a meeting, issues surrounding regular and special assessments, a community's insurance requirements, and maintenance obligations, just to name a couple. With that, Colorado has many great law firms that represent both the association and the homeowner with various types of disputes. While the HOA Center does not endorse any one particular party, such as a unit owner or a unit owners association, we do believe it's in the best interest of the public to understand all sides of an issue, whether that issue involves a broken water pipe, records, assessments, or simply how to foster a stronger sense of community. All right, so with that, I will introduce today's guest speaker. Lindsay Smith is a partner at Winzenburg, Leff, Purvis Payne, where she practices in general community association and real estate law. She provides legal representation in covenant enforcement, eviction, document amendment petitions, and general association litigation, contract and document drafting and review, general business and governance advice for association clients, and meeting protocols. She works on legislation impacting associations and is the former chairman of the Community Associations Institute's Colorado Legislative Action Committee. And Lindsay, I'm going to go ahead and end my screen share here and turn my video off. Feel free to share your screen and take it away.
All right. Thank you so much, Nick. Thank you, Amanda, and everyone at Dora for having me here today. Going to work on getting my presentation here started. So it's Winzenburg, you know, for whatever that's worth. You know, it's one of those strange names, and Jim Winzenburg and Larry Leff founded our firm some 40 odd years ago, and we've represented community associations pretty much exclusively since the 90s. I've been working at Winzenburg since 2009, and my first few jobs after I got my bar license, they were working with special districts and real estate litigation and things like that. And I thought to myself, I understand now why every lawyer is miserable, because this is just such a drag. It's such a grind. And then I started working in the HOA context, and I realized how fascinating and how interesting all of these different problems that HOAs face could be. You know, today I'm working on a fair housing dispute. Tomorrow I'm working on a cattle ranch where people are trying to figure out how to keep the cows off of their property. So it's just a very narrow practice, and also so incredibly broad that I love doing what I do. I love working to fix problems and to help our communities be stronger. And one of the things that I think is really important is for our homeowners, our community members, to understand exactly what these powers that the association has, what that means, because you talk about a lien and it scares everybody. They say, oh my gosh, they're going to take my house. They've got this lien. It's horrible. This is unconstitutional. But a lien, let's get right into it. To understand the HOA lien, I think you need to really understand what a lien is generally. And a lien is a security interest against property. It could be real property, like your house. It could be personal property, like your bank account, that's designed to secure performance of an obligation. So you have a lien because you promised to do something. Liens can be consensual and they can be non-consensual. A consensual lien arises out of a contract, like your deed of trust or mortgage. A non-consensual lien arises out of statute or a case law, common law. Various types of liens that you may have heard about. Mechanics lien. My neighbor shovels my driveway and I don't pay him. Any person who puts value into your property through work or through materials is entitled to file a mechanics lien when they're not paid for that work. A judgment lien. I don't pay my credit card. The credit card company takes a judgment against me. The judgment lien can be recorded against any property that I own in the state. And so if I own 5 properties in Douglas County and my creditor takes a judgment against me, they can go get it's called a transcript of judgment. They record that one transcript of judgment in Douglas County, and all 5 of my properties in Douglas County are then subject to that judgment lien. Tax lien, that's another non-consensual lien, and we always know that the government will decide that it's going to get paid its taxes. So tax liens, we'll talk about this later, are very senior in priority. They will always ultimately get paid. Mortgage lien, that's a consensual lien. So the mortgage lien exists when you sign your promissory note and your deed of trust. And you chose to do that because you wanted to buy your house. And the lender says, I will give you this money to buy your house, but you have to promise to give me collateral in that house. The HOA lien is kind of both consensual in that you purchased a house in an HOA, knowing that it could be subject to a lien, and it's non-consensual in that it arises without you signing, on the mortgage like you do with the promissory note and the deed of trust. Some states have different other kinds of liens. I know I went to school in Oklahoma, And Oklahoma has attorney liens, where the attorney can file a lien claim on the proceeds of a lawsuit to make sure that they get paid before their client gets any money out of them. I saw recently, when I was doing some research in Texas, a hospital lien where the hospital could file a lien against a person's house for non-payment of their hospital bills. In Colorado, the process for a hospital to get paid by a lien would be the judgment lien process and not an independent hospital lien. But there are a lot of different types of liens that can exist. So how are liens created? Typically, it depends on the lien. That's such a lawyer answer. It depends. Liens are created by operation of law. So the tax lien and the HOA lien, those exist the minute you don't pay what you owe. The HOA lien, it exists the minute you owe a penny, even if that separate piece of paper is not recorded in the county records. Other liens, like the mechanics lien, like the judgment lien, those are created by recording a document in the county records, the county clerk and recorder's office. Liens are perfected when they are recorded, and perfecting a lien means that you are establishing an order of priority. The priority becomes very important when it comes time to use those liens to get paid for something. So what good is a lien? Like we said earlier, liens are leveraged to compel somebody to pay you something that they owe to you. Liens may be used to threaten or undertake foreclosure. Oftentimes, a lender who gets notice that an HOA lien exists or that a tax lien exists, they'll pay that lien so as to protect their mortgage on the property, and then they'll add the amounts that they pay to the principal balance of the mortgage. So a lien is not always going to be used for foreclosure, and a lot of liens, it doesn't make sense to do for foreclosure. So we're going to have a little story time to talk about liens and how they operate in real life. And our story is Mr. Greenacre can't pay his bills. In law school, property class, first year, there's always Greenacre and there's always Blackacre when we're talking about different types of estates. And it's always an estate. You know, it's never a lot. It's never a condominium. Everyone's got an estate. So Mr. Greenacre contracted for some work to occur on his estate, Blackacre. Blackacre's his home, which he purchased for $350,000 in 2019. And he probably closed on that, you know, March 10th of 2019. So now it's worth $500,000. Probably it's worth more with how things have been over the past several years, but we'll say it's worth $500,000 now. Mr. Greenacre took out a second mortgage because he wanted to pay for some upgrades, but then he spent the money in Blackhawk, lost his job, gambled away his company's petty cash. Mr. Greenacre's HOA provides snow removal, common area maintenance, and trash removal for $100 a month. So again, think about those. Those are services that are being provided to benefit Blackacre, to benefit the property. Mr. Greenacre stopped paying his mortgage in late 2023. Now the bills are coming due, and Blackacre, his estate, is finding itself encumbered by a variety of liens. How do the bills get paid? This is a lien chart that it's all our hypothetical liens that I prepared based on our story. And it goes from the top lien is the most senior lien, and the bottom lien, the judgment lien for the credit card, that's the most junior lien. And senior liens and junior liens are important concepts to understand when doing lien analysis, and especially with the HOA lien. So our most senior lien, that's our tax lien. Then we have what's called the HOA super lien, which is equal to 6 months worth of HOA assessments. Then we have our first mortgage. Then we have the rest of the HOA lien. So it looks like he's not been paying the HOA $100 a month for over a year at this point. Then we have our second mortgage, and looking at our second mortgage and the other liens, you can see that the recording dates get later and later and later. And so the first recorded date is the most senior lien, except as provided by statute. And that's why no matter when the taxes came due, they're the most senior lien because that's the law. Same with the HOA super lien. Even it's senior to the first mortgage deed of trust, for policy reasons that we'll discuss later, equal to 6 months worth. But then when you have the mechanics lien by the painter and the mechanics lien by the carpenter and the other liens that we have here, the recording date is increasingly important. Those don't have special statutory lien priorities. They are based solely on the date they are recorded in the county records. So looking at this, we've got two mechanics liens. We have a judgment lien that the painter took, and we have a judgment lien that a credit card company took. Again, the credit card company lien is the most junior lien. The tax lien is the most senior lien. So that's our hypothetical landscape for our liens here. All lien holders have the right to foreclose against Blackacre. Foreclosure is a process by which a property is sold at auction, either by the public trustee for most mortgages or by the sheriff for judicial foreclosures, which are run by the district courts in Colorado. HOA liens, judgment liens, and mechanics liens are done by judicial foreclosure. Almost all mortgages are administered by the public trustee system. Sometimes you have to take a mortgage to judicial foreclosure if there's a problem with the documents, but the public trustee system is just much more efficient, and it's set up to handle mortgage foreclosures. So looking at our junior liens, the mechanics lien in our liens in our lien chart, they're junior liens. They are junior to the mortgage. They are junior to the HOA. When a junior lien holder forecloses, the lien holder takes title to the property subject to our senior liens, our tax lien, our HOA liens, our first mortgage lien. Here, if the carpenter foreclosed his lien, he would take title subject to $330,600 in senior liens between the taxes, HOA, the painter's lien, because see, it's one day more senior than his lien, and the mortgages. For the carpenter to be able to take that property and then sell it to get paid, he'd also have to figure out how to pay those senior liens off. So he also, because this is a mechanics lien, there's a homestead exemption that doesn't apply in HOA cases or in tax cases, in first mortgage cases. So the carpenter would also have to pay Mr. Greenacre the homestead exemption. In other words, foreclosure of a mechanics lien in a case like this just doesn't make an awful lot of sense. Rather than foreclose, our painter decided to take Mr. Greenacre to county court and obtain a personal judgment. So you see, that's why we've got the two liens. One's the mechanics lien by the painter, and then we have the judgment lien by the painter. The personal judgment allows the painter to try to garnish Mr. Greenacre's assets, of which there are probably none at this point. And it also creates that judgment lien. A mechanics lien only holds the property for 6 months if you don't initiate a foreclosure. The judgment lien will apply to the property for 6 years. And so it's important to make a decision as the creditor what kind of process you want to undertake to get paid at the end of the day. But at the end of the day, what we really have here is a guy who is down on his luck and is not paying his bills. The lender, the first mortgage lender, is often going to initiate foreclosure in these circumstances. The lender will consider the viability of the foreclosure, equity in the property, extenuating circumstances. Is there a bankruptcy? Is this person in the military? And then it'll decide whether it's going to initiate that public trustee foreclosure. When the lender initiates a foreclosure, it'll pay off those senior liens. So it'll pay off the tax lien and it'll pay off the HOA super lien so that it has the most senior rights to the property. If the foreclosure goes to sale and no junior lien holder redeems the foreclosure, which we'll talk about in a slide or two, the lender is the one who takes title to the property. And that's because the lien holder has to bid its debt to take title to the property in the foreclosure sale. Lenders require waivers of the homestead exemption, so Mr. Greenacre is not going to be paid out by our foreclosing lender. Redemption is super duper important when we're talking about our junior lien holders in foreclosure. Redemption allows a junior lien holder to pay off senior lien holders to take title to the property. They'll file a notice of intent to redeem, and that notice of intent will say, I, as the HOA lien holder, am owed $1,000, and I want to pay off the senior lien holders to get title to the property. If there are overbid amounts, you can file that notice of intent to redeem and not actually redeem. But the goal of any foreclosure in Colorado as a policy provision is that that property, if it's got to go through foreclosure, any debt that is associated with that property should be paid off. And that protects Mr. Greenacre from personal liability and future garnishments and things like that, because the house was sold, the proceeds will go to pay off those creditors. Now, redemption gets really complicated because all of the junior lien holders theoretically could file an intent to redeem. But at the end of the day, the most junior lien holder is the person who gets title to the property. They just have to pay off all of the senior lien holders. So in our redemption chart, say we've got the tax lien paid off, we've got the super lien paid off. The first mortgage, that's been foreclosed and included in the bid. Then all of our other lien holders, they file their intents to redeem. Now, let's see how this works in real life. So if Blackacre sells for $400,000 because everyone was bidding to get a piece of the property, and the lender bid its debt plus costs of $305,000, there's a $95,000 overbid. Because the HOA and second mortgage filed their intents to redeem, they'll be paid out of that overbid $69,000 remaining. Mechanics liens, those are extinguished because nobody filed their foreclosures within 6 months of the completion of the work. The mechanics liens don't mean anything at this point. Our hypothetical painter didn't realize that the house was in foreclosure, and so he didn't file an intent to redeem, and his lien is extinguished. It's wiped off of title. Investors are really important in redemption. Our credit card company sold its lien, its hypothetical lien, to an investor, got paid its $5,000, is out of the picture. But now we have this investor who pays off all of the people above him, takes title to the property, and there's $64,000 left after paying off all of those senior lien holders in the overbid funds. The investor takes title to the property, renovates it, flips it. He comes out of the whole process with $150,000. Mr. Greenacre, who is now, who knows where he's living at this point, he's entitled to the remaining overbid funds, and he will not owe his lenders, his HOA, or his vendors. The property sold to pay off all of those people. So what about poor Mr. Greenacre? Several years ago, the foreclosure statutes were structured so that homeowners could so that homeowners could redeem a foreclosure after the sale. And the way it was structured is there was a very short time before the sale for the foreclosure notices and a long time after the sale for the redemption period. The legislature changed that to make a very long time between the initiation of a foreclosure and the sale, and a very short time for redemption only by those lien holders. And the reasoning is that not a lot of homeowners were actually redeeming, and it creates a lot of confusion and uncertainty with title, with the possibility that a homeowner would redeem after the foreclosure sale. So we have a very long cure period before the foreclosure sale so that the homeowner, without having, to risk his property having already been sold and maybe even being evicted, the homeowner has a time to cure before the foreclosure sale. And the homeowner just sends the foreclosing party a request for a cure figure. If they come up with that money, then all's well and good, and the foreclosure stops. With our friend Mr. Greenacre, because the house went all the way through foreclosure and redemption, he's entitled to those overbid funds. If any of you have friends who went through foreclosure, make sure they check about those overbid funds. That doesn't happen in every case, but a lot of homeowners don't realize that they're entitled to that money, and they've got, $50,000 sitting on the unclaimed property list, and that's money that they definitely could use in real life now. So that's a big, long overview of liens in general. HOA liens are a special kind of weird creature. Like I said, they're created both by statute and by contract. When you purchase your home in the community, you purchase it subject to a declaration, covenants, or some other document that's recorded against title to the property. The concept is that the document ties to title to your property and creates obligations to pay money and to perform particular work or maintenance. And that might be the HOA that has to replace your roofs. It might be the HOA that has to run architectural control in the community. It might be the condominium association that provides common water. There's some obligation to pay money for services that benefit the property. Once you owe a penny, once your assessment is a day late, the statutory lien pops into existence. You don't have to record a separate paper lien for there to be an HOA lien against your property. You just have to owe money. Once the HOA complies with CCIOA rules regarding notice, offering payment plans, and the board approval to turn over a file for collections and for liening, the HOA will perfect its lien by recording that paper lien against the property. And we always record those paper liens because that, one, it gets everyone's attention, and two, it avoids any confusion. Like if a homeowner sells, it makes sure that the title company, or if they refinance, it makes sure that the title company knows that money is owed to the HOA against that property. Now, we talked about priority earlier, and HOA liens are really weird in that the priority of the HOA lien isn't the day that the paper lien is recorded against the property. It's the original recording date of the declaration. So if my declaration was recorded in 1963 and I buy my house in 2020, and then I don't pay my association bills, my HOA lien legally has a priority of 1963. And we'll talk in a minute about why that is and how that works here. In Colorado, based off of changes in the law under House Bill 1137, some parts of the HOA lien are foreclosable and other parts are not subject to foreclosure. You could use those other items like fines, late charges, and certain attorney fees for purposes of redemption. But if you need to, if there's a foreclosure and the foreclosure debt only occurs or only includes things like fines, it's not actually foreclosable. So we have to do a pretty strict analysis now of any ledger to make sure that the HOA actually does have the right to foreclose, because oftentimes there might be amounts owed by a homeowner, but it wouldn't be foreclosable because of those changes in the law. So the relation back of the HOA lien to the original recording date, lenders hate it because they don't want to have their first mortgage deed of trust be junior to the HOA lien, because then if the HOA forecloses, it wipes out that first mortgage deed of trust. And that would be how it would be if we didn't have the super lien and the way that Colorado and many other states have structured the super priority association lien. So our version of CCIOA is based on the 1982 Uniform Common Interest Ownership Act, which was created by the Uniform Law Commission. The Uniform Law Commission, back then, I think it was called NACUSL, they take a lot of stakeholders. So they get the lenders, they get the HOA people, they get the homeowners, and they try to put together laws that make sense for broad application, with the goal being that all states are going to adopt the uniform law. So the Uniform Nonprofit Corporation Act, the Uniform Dissolution of Marriage Act, things like that. Our 1982 UCIOA is 3 or 4 iterations old compared to the most current uniform law. But what's important about the uniform laws are the policy on the HOA liens. Like I said, they brought in a bunch of stakeholders to discuss HOA liens, and the lenders said, we don't want to lose our lien, our mortgage rights here. So NACUSL said, as to prior first security interest, the association's lien does have priority for 6 months of assessments based on the budget. A significant departure from existing practice, the 6-month priority strikes an equitable balance between the need to enforce collection of unpaid assessments and the obvious necessity for protecting the priority of the security interests of lenders. As a practical matter, secured lenders will most likely pay the 6 months assessments demanded by the association rather than having the association foreclose on the unit. Back in 2008, when property values were terrible and the economy was in the tank, there were a lot of communities with vacant homes, vacant condominium units, where the lender wasn't paying, or where the homeowner wasn't paying anything, wasn't paying the lender. The lender didn't want to foreclose on the property because foreclosure is bad for property values. It is, a lot of lenders would much rather not be in the business of dealing with that foreclosure in the first place. And so what you see happen is the lenders will sit on a foreclosure rather than initiate the foreclosure because they are hoping that property values will increase and they'll be able to do better at the ultimate foreclosure sale. The problem with that is that the HOA still has to provide the services. It still has to pay the insurance bill. It still has to provide the trash service, whatever that has to be. So we would see HOAs that couldn't pay the bills because the homeowner was gone, the lender wasn't doing anything. And so the HOA being able to trigger the lender's attention by threatening to foreclose the super lien at least allowed the HOA to get 6 months worth of assessments to be able to keep the lights on, to be able to pay those bills. So that's the policy of the super lien. I know a lot of people think that the super lien is always being foreclosed on and is really problematic. At the end of the day, a super lien is almost never foreclosed on because the lenders receive notice of any foreclosure and they just pay that $600. They just pay that 6 months worth of assessments to protect their rights in that property. So that's the general HOA lien type stuff. I do have, I talk really quick when I'm excited. Wow. I'm going to speak to some of the questions from the public, and I know we've got some in the Q&A as well, so I'll take a look at those. The first one is, could you speak to the legal process in which an association's unpaid debt on assessments is transferred or sold to a collection agency? What does the collection agency do with that debt? And I looked at this and I thought, you know what, I really can't. A lot of management companies will work with collection agencies rather than send things to the attorneys because the attorneys are too expensive. Anytime there's a referral to collections, the board of directors has to vote in executive session to approve that referral, whether it's to the attorney's office or to a collection agency. Collection agencies will generally go about the same process of trying to get a judgment against the homeowner. One of the things that we see with the HOA lien and collection referrals, whether that's to or getting paid at the end of the day by selling that HOA lien to an investor, is there's a big risk in selling an HOA lien to an investor because we do not want our homeowners to be at the whims of an investor who might try to foreclose on them when maybe the homeowner has cured everything else. You know, they've cured the mortgage non-payment. So our process for selling a lien, which again, there's the personal obligation and there's the lien obligation. Our process for selling a lien is to never sell a lien until the foreclosure sale for that lender foreclosure has already occurred. Because at that point, the only right is the right of redemption. There's no right to cure. And we don't have to worry about an investor abusing a homeowner who just got out of hot water with their mortgage holder. So I don't know if that exactly answers that question. Like I said, we don't do any work with the collection agencies ourselves. Anecdotally, I've had a lot of clients say that the collection agencies tend to be both more aggressive and less effective than the attorneys. I like for my boards to be able to keep control of what's happening to their homeowners, because at the end of the day, those are their neighbors that they're sending to collections. And, you know, you don't want to tell your neighbor, sorry, we sold the debt to a collection agency, sorry, they're kneecapping you. We want to be able to be humane and work on those community relationships and not just look at the bottom line. Associations have a fiduciary duty to collect. You can't just ignore those unpaid assessments, but that doesn't mean that you have to be completely heartless. You just have to make sure that when you're doing that collection, you are treating people equitably and also not having the rest of the community subsidize somebody who's not paying their assessments. So there's a balance between treating people with dignity and making sure that the bills get paid. And I think that keeping those types of collection actions in the control of the board is the best way to keep that balance. So I'll get off my soapbox on collections there. This is a fun question because I love limited expense planned communities because they're so wild. Could you speak to the limitations on an association's ability to file/enforce a lien in a limited expense planned community? A limited expense planned community is a community that in its declaration has certain limits on the amount that it's allowed to charge for assessments. Somewhere, I think it's around 600 some odd dollars at this point per month. And they are only subject to the parts of CCIOA that are public policy provisions. So the obligation to allow for xeriscaping and family childcare homes, and for no obligation, we can't make them put on shake roofs and those sorts of public policy sections. Those apply to limited expense communities. The lien provisions don't apply at all. And so any right that the association has in a limited expense community to file, foreclose, et cetera, a lien is dictated completely by what's in that declaration. And the changes in the law that we saw with House Bill 1137 regarding what's a foreclosable lien, those don't apply to limited expense communities either. So whatever's in the declaration is going to dictate the ability for a limited expense community to file or enforce a lien. I also fully expect somebody to mess that up. I can't tell you how many times I've seen a limited expense community that is relying on provisions of CCIOA that simply don't apply to it. So the difficulty with a limited expense community is they need a lot of handholding because of their unique structures and their limited expense. So they don't really have the money to pay for legal advice to get that handholding. But yeah, very interesting question. And you think about it, limited expense community, even at the higher end of the budget, that's going to be like $600. It's $600-ish per year, I think. That's you could file a lien with that kind of money owed, but it'd be a really hard idea to foreclose on that lien. Also, thinking through this, the limited expense lien, depending on the declaration, might be wholly entirely senior to the first mortgage lien. But that's going to depend entirely on the individual declaration. Just that whole section of CCIOA dealing with liens and lien priority doesn't apply at all in this context. So how soon should a lien be recorded when a delinquent owner has failed to respond to a notice of delinquency? I think this is a decision that is probably a policy decision for boards to make. A lot of communities are trying to get things recorded and maybe the collection process started maybe 90 to 120 days after the delinquent owner has commenced their delinquency. That can obviously be extended if the owner does respond to the notice of delinquency, enters into a payment plan, and maybe defaults on that payment plan, then comes back on board with the payment plan. Because we have our statutory lien, regardless of the recorded lien, I don't panic if I don't have a lien recorded promptly after a failure to respond to a notice of delinquency. But like I said, there is that fiduciary obligation to go ahead and enforce those covenants to pay the assessments. So I think that a board that just kind of doesn't take any action in response to a delinquency, that's problematic too. It's a policy decision. You know, there are expenses associated with recording a lien, whether it's done by a management company or turned over to legal counsel. I'd also, getting back on my soapbox here, it's rare to see a self-managed community that records liens correctly. So we don't want to have a spurious lien or a lien that is not valid. So if you need to record a lien, please have your professionals do it. It's just a really big risk if it's done incorrectly. Getting off of that soapbox, I think 90 to 100 days, 120 days or so is about typical for what we see for when a lien is recorded. Should an HOA's lien remain in place after a delinquent owner has paid their assessment but still owes late fees and other charges? In other words, the owner has made a partial payment to the HOA. My opinion is yes. And one reason for that is because even if you release the notice of assessment lien, there is still the statutory lien that remains in place. The other issue is that if we release a lien when the association has not been paid in full, that confuses the owner because they will say, wait a second, you released my lien. Now you're telling me that I owe more. So I think it's, from a policy perspective, one, the lien's already there. It's not going away anywhere. And two, it will confuse your owners if they start getting notices that they're still delinquent than when they think that they have, cured that delinquency. Next question is my favorite. If an HOA initiates foreclosure and the owner abruptly pays the delinquent assessment, can that owner short circuit the foreclosure, preventing the HOA from being able to recover its legal costs via foreclosure? In other words, after starting the legal work of foreclosure, is there a window of time during which the owner could pay the delinquent assessment and escape responsibility for paying the HOA's legal costs? I thought this was kind of an interesting question from an attorney ethics perspective, as well as from the HOA perspective. As I mentioned earlier, homeowners have the right to cure a foreclosure. And so if the HOA has initiated the foreclosure, the owner has the right to cure the foreclosure. But when you are seeking a cure figure for a foreclosure, you have to ask for that from the initiating entity or the public trustee. You can't just pay the delinquent assessment because the foreclosure statutes and Colorado law allow for award of attorney fees and costs associated with foreclosure. So you can't avoid your responsibility for paying the HOA's legal costs when it's gotten to that point. There's also ethically, from the attorney perspective, when we do our foreclosures on a fixed fee. And so when we as attorneys do work on a fixed fee, we aren't supposed to be paid until the particular work is done. So if I do a document amendment, I might charge $6,000 and I will do 3 drafts. And the first 2,000 is due after the first draft, and then 2,000 more after the second draft, and so on and so forth. I could see a problem if the foreclosing party charges the entire foreclosure fee. They charge $3,000 when our abruptly paying owner pays on the day that the lis pendens, which is a document recorded in the county records that shows the initiation of the foreclosure, when that is filed and nothing else has been done in the foreclosure. So long story short, you can't escape responsibility for paying the HOA's legal costs simply by paying the delinquent assessment. But I think that as attorneys, we need to be cognizant of our duties to charge for the work that has been done and not for the work that we're planning to get done down the road. So I'm going to move into our Q&A box here, because these are always good questions too. What would you suggest an HOA do when a homeowner with liens threaten to disband the HOA? Bring it, come after me. A lot of times you will have provisions in the governing documents that require owners to be in good standing in order to vote. It's by no means universal, but that is very common. And so I'd first ask, is this even something that can be done? Most of the time, it's not something that can be done. It's simply disbanding the HOA is something that has to be voted on by at least 2/3 of the homeowners. And something that a lot of people don't realize is that even if the common interest community corporation is terminated, that doesn't terminate the covenants on the property. It doesn't terminate the obligation to, get architectural approval and things like that. So a lot of folks will threaten, I'm going to disband the HOA, but the reality of being able to do that is very close to impossible. Does the HOA attorney represent the best interests of the board? No. As the attorney for the nonprofit corporation, I work with the board, but I do not represent the board itself. I represent the corporation. And that means sometimes I have to tell the board, you're doing something dumb. Stop doing this. Don't do X, do Y, do better. And so it is my duty to act in the best interest of the corporation and not in the best interest of a particular board member or anything like that. Okay, it is my understanding that an HOA cannot file a lien without getting a signature that you have delivered a notice of intent to file a lien for non-payment of dues. Because of changes in USPS, we've been unable to get return signature on certified return receipt cards through the USPS. Can you lobby the legislature to allow us to use UPS or FedEx with signature required to obtain payment and secure our right to file a lien? So House Bill 1137, I was 9 months pregnant and on clack with that one, and I cried a lot. It was a really tough bill. It does not require that we have a signature. It requires that we send by USPS certified and email and or text message and or regular mail. It doesn't require that signature card. And that was something that we testified about and that we brought up, is that in an HOA or in a certified mailing context, what it really teaches you, or what you really can prove, is that the mail actually didn't get picked up. I left my trash cans out for too many days last summer, and I got a letter from my HOA and an email and a certified mail. And I knew exactly what the certified mail was, so I didn't ever go to pick it up because, I've got too much stuff on my plate already. So the long and short of it is you have to send it by certified mail. That doesn't mean that they have to pick it up. Please explain placing a lien to recover court award from a lawsuit. So you have a lawsuit, you have a judgment. You go to the court clerk, you ask the court clerk, may I please have a transcript of judgment? The court clerk will print out a transcript of judgment. It's usually 1 page. It says what's owed and the court case number and everything like that. You put your mailing address on there, make sure that the mailing address is on there, and you record it in the county records. And that's what creates the judgment lien. You never record the judgment itself, you record the transcript of judgment. Okay. Where would a $16,000 roof assessment lie with regards to the lien? There's no other debt. However, there's no money to pay this assessment for the roof. So a special assessment is the same sort of lien as any other HOA assessment. And oh, there it is. And the application of payments in the collection policy for the association will specify how payments are applied to that special assessment. It would just be the same as any other special assessment. Since this is a special assessment related to the roof, make sure you've talked to your insurance company. You might have loss assessment coverage that can help pay in whole or in part that kind of assessment. It really depends on the specific facts of every individual case as to whether loss assessment coverage is going to exist or not. So I can't tell you if it'll exist or not, but please make sure and talk to your insurance agent just to see if it's possible. If a HOA really doesn't want a homeowner there anymore, what would be the best way to evict or foreclose? I'm talking about drug dealers. So years ago, I had a homeowner who allowed mice into the unit, was threatening people, gunning his car at people in the parking lot, making real threats of violence, just being a real poor neighbor. And this was years ago, and the HOA decided that every time he, did these sorts of things that were in violation of their rules, that they'd fine him, and that eventually they could fine him enough to foreclose against him and get somebody into the community who maybe wouldn't be such a threat. Today, fines are no longer foreclosable. So you cannot foreclose on fines. The only way that you could evict someone would be if they didn't pay their regular assessments and you foreclosed and you took title to the property. Because of the way that House Bill 1137 requires the application of payments, even if somebody's not paying their regular assessments, or I'm sorry, somebody's not paying their fines, those regular assessment payments go to pay off the assessments. They don't go to pay off fines. The fines just kind of sit there. So foreclosure and getting a real bad actor out of the community was extremely difficult, but theoretically possible a few years ago. I don't really think it's possible anymore in light of how House Bill 1137 makes fines no longer subject to foreclosure. Please define periodic budget for the super lien. Are the 6 months determined for the current year's amounts or a different period of time, such as oldest fees owed? That's a good question. I think it's periodic budget for the then current year. Let me see if I can't find it real quick. I typically would interpret it as the periodic budget for the year in which the debt comes due. Based on a periodic budget adopted under the association under the budgeting law. So it doesn't say which year's budget it would be. I would interpret that as the budget that is in place at the time the debt comes due. Is property damage to HOA common property a foreclosable lien? As long as the declaration permits that kind of default assessment or individual assessment, and it's not a fine, then that would be a foreclosable lien.
Lindsay, let me go ahead and jump in here and take one, just in case you want to take a quick breather. One question posed by an attendee here is, where can I find information on a limited expense community? It's never been mentioned in the webinars or discussions. So CCIOA section 38-33.3-116 of the Colorado Revised Statutes kind of talks more about this notion of a limited expense community. And in a nutshell, it says, it grants rather an exception for those types of communities for many of the statutory requirements in CCIOA, except for sections 105 to 107, which in part address public policy concerns and unreasonable restrictions on energy efficiency measures and EV charging systems. So that would be CCIOA section 38-33.3-116 would be the answer to that one.
Like I said, they're super interesting, weird little creatures because they try to take advantage of as much of CCIOA as they can, but they have to have it in their declaration. Tara asks, what if the HOA is responsible for fixing a home but fails to pay or refuses to pay for the work completed? How would the homeowner know if a lien was placed on the home if they didn't receive any communication? So if the HOA doesn't pay a bill, and this would be a mechanics lien context, the mechanics lien statute requires notice to the people who contracted for the work as well as the property owner at least 10 days before a mechanics lien can be filed against that property. Could you discuss the potential lien situation where a property owner is current on HOA dues but has refused to comply with an existing covenant, e.g. failed to install specified roofing? This is the hard thing about the recent changes in the law. It used to be that to enforce a covenant like that, the association would say, hey, do it or we're going to fine you. No, we're really serious. We're really serious. And, levy $5,000 in fines against the property until the homeowner says, fine, I'll fix the roof. Can you give me a break on these fines? And the HOA would say, yes, we'll waive the fines. Please just fix the roof. Now that fines for non-health and safety violations are limited to $500 and fines are no longer foreclosable, they're not the threat that they used to be. And so we're seeing in our offices more escalation to legal for those types of issues. And when the file's escalated to legal, obviously there are the legal fees that the HOA has to incur that may or may not be approved by the judge in subsequent litigation. So when those legal fees are approved and everything, then you do have that lien, that HOA lien for the costs of the litigation. You still won't have a foreclosable lien for the fines themselves, and the attorney fees are also not going to be part of the foreclosable lien. So again, you end up looking at a personal judgment or trying to garnish a bank account, or you wait for, if it's a district court case, you have a 20-year lien viability for that property. And maybe that means that the homeowner will refinance and the HOA will get paid then. Long story short, if the homeowner is not willing to enter into a payment plan for that type of a violation, it could take a really long time for the HOA to ultimately get paid. Okay. What percentage can be added if homeowners are behind 90 days? Ours is 18% per annum. I was told that completely dropped. Yeah, it's 8% interest per annum now under House Bill 1137. All right, Bruce says that the notice was lost in the mail. Can't get notice that the certified mail was delivered, nor was it returned. I think that as long as you are sending it, that's what the statute says. It says you have to send that mail, certified and regular USPS and email or text, or there are a variety of ways that you can send it. There's nothing in the statute that says that you have to provide proof of receipt. There is a presumption legally that a properly addressed, properly posted mail piece that does not get returned to you reaches its destination. So while again, that the certified mail did not reach its destination, there's at least a legal presumption that the regular mail did reach its destination. And so, Nick, I think right on time, right at 2 o'clock, I think I've got all of the, oh, there's another one. We have a home that has been vacant for years. The windows are broken. They do not lock. What can we do? Smoke alarm's been going off for months. Owner passed away. Are we responsible for fixing the house? Great question. Depending on the rules of your governing documents, you might be able to undertake self-help, which is when the HOA goes and fixes things and then charges it back to the house. Doesn't sound like an ideal situation in this circumstance. Something that we've done in cases where we have a homeowner who's passed away and no assessments are being paid, we will have a probate initiated for the property so that it can be taken care of by the heirs who maybe aren't doing things properly. There are options to deal with those types of homes. They are, again, oftentimes expensive and they can take a lot of time to get things resolved, but go ahead and call the association attorney, and there are options. You don't just have to sit there and live with that house like that. You might be able to get an injunction allowing the work to be done and the property sold to pay the HOA to get that work done. But those, like I said, those are pretty extreme and expensive types of opportunities that you'll want to talk through in detail with the HOA attorney. You could also potentially have a receiver put in place for that property if it's delinquent with the assessments or and you're going into foreclosure. And the receiver will go in, fix the smoke alarms, fix the windows, and take care of the property, get a renter in there, and eventually get the HOA paid up So it would be kind of a win-win there. Again, receivers are expensive, but that's something that might be available depending on what's owed on that property. And can we enter the home? So a lot of covenants say you can do X, Y, or Z. I hate it when I have clients that want to enter the home because that's how people get shot. A lot of vendors are not willing to enter a property. What you can do when you have these self-help issues, you can, rather than risking being shot, you go to the court, you get a judgment, you say, hey, Your Honor, we need help to, fix the fire alarms. And the judge will say, here's your writ. And you'll go to the sheriff and say, Sheriff, I've got this writ. Can you please help me get into this property? I've got my locksmith here. And the sheriff will help keep the peace to make sure that the vendor who wouldn't go in otherwise is safe. So again, there are options for these types of circumstances. They're not simple. All right, I'm going to stop my screen share there.
All right, let's see if I can throw a quick slide up here real quick before we end. Well, thank you so much, Lindsay, for that presentation. It was very insightful, and we certainly appreciate you sharing your vast knowledge about HOA liens and liens in general. I did have one consumer ask if you could repeat kind of what an HOA lien is composed of in terms of the assessments, attorney fees, fines, late charges, and whether you can kind of, I know you might have had a slide earlier, but can you kind of discuss real quick what a typical HOA lien is composed of, and I guess what is collectible?
Sure. So everything's collectible, but as far as what's foreclosable, the assessments are collectible, foreclosable. The regular monthly assessment, the special assessment, that's part of the bread and butter lien for the HOA. Under House Bill 1137, fees, charges, late charges, attorney fees approved by a court, fines and interest on late assessments are subject to a statutory lien, but are not subject to a foreclosure action. So again, the entire amount owed is part of the lien, but the entire amount owed is not foreclosable.
Gotcha. And then could you also reiterate the lien priority order of operations? You said the lender HOA lien comes before the lender, correct? If I heard that right?
Yeah, it's a bifurcated lien. So the most senior lien is the tax lien. Then you have 6 months worth of HOA assessments. Then you have the first mortgage, which is the bulk of any amount owed on the property most of the time. And then you have the remainder part of the HOA lien. So it's bifurcated with the first mortgage in the middle of it.
All right, great. Well, there is contact information here in case we were not able to get to any of your questions today for the attendees on the call. Winzenburg has their website, www.cohoalaw.com. If you wanted to visit their website. I also wanted to thank everybody for attending our presentation today, and especially Lindsay for joining us. Thanks for sharing your knowledge and for making our forum a success. And unless there's any other questions I didn't get to in the Q&A, this will conclude our March HOA forum. So Lindsay, thank you very much again, and we'll look forward to seeing everybody next month, and have a great